Busting green card myths. U.S. citizen relatives face long waits too. Despite common beliefs, obtaining a U.S. green card through family ties isn't always quick. Even U.S. citizens' relatives can face long waits. At the same time, the U.S. government is cracking down on visa fraud, targeting aid groups, and reigniting legal debates over birthright citizenship. If you're interested in this topic, please pay attention and watch the video through to the end to get all the information. Please hit like and subscribe, and don't forget to push the notification bell for an upcoming video. Being related to a U.S. citizen doesn't always mean a quick path to a green card. While some family members qualify for faster processing, others may wait over 15 years, sometimes decades, depending on the relationship and country of origin. If you think your sibling can get a green card quickly just because you're a U.S. citizen, that's a myth, said Abhishek Parikh, a U.S.-based immigration lawyer. The fact is, only immediate relatives, spouses, parents, and children under 21 get priority. Others, like siblings or married children, might be waiting 15 years or more. Under current U.S. immigration law, family members of citizens and lawful permanent residents can apply for green cards, but delays depend heavily on their visa category and country of birth. 1. The Visa Bulletin Q, which determines when you're eligible to apply. 2. The USCIS processing time, which starts once your application is submitted. Immediate relatives of U.S. citizens skip the Visa Bulletin Q entirely. For others, both queues apply, sometimes spanning decades. For Indian nationals, the green card backlog is among the worst in the world, especially in categories like F4, siblings of U.S. citizens, and F1/F3, adult children of U.S. citizens. Varun Singh, managing director at Ziphia's Immigration, told Business Standard. The reason is a country cap that limits green cards for each nation to about 7% of the annual family base total, regardless of demand. Singh explains, siblings of U.S. citizens, 15 to 20 plus years. Adult children of U.S. citizens, over 10 years. Children under 21, 1 to 2 years. Spouses of U.S. citizens, 12 to 18 months. Spouses fall under the immediate relative category, so there's no quota. That's why their green cards are processed faster and with fewer hurdles, he said. Family-based green card waiting times, financial year 2025. Here's how long family-based green cards take, based on USCIS data. Immediate relatives of U.S. citizens, no visa bulletin wait. Spouses in the U.S., 9.5 months. Spouses abroad, 14.3 months. Parents, 14.3 months. Unmarried children under 21, 14.3 months. Family preference categories, visa bulletin applies. Spouses/children of green card holders, F2A October 2024, 35 months. Unmarried adult children of U.S. citizens, F1 September 2017, 9.5 months. Unmarried adult children of green card holders, F2B January 2017, 35 months. Married children of U.S. citizens, F3 July 2012, 9.5 months. Siblings of U.S. citizens, F4. India, October 2006. Most other countries, April 2008. Mexico, April 2001. Philippines, January 2008. USCIS time, 9.5 months. Family preference categories defined. F1, unmarried adult sons/daughters of U.S. citizens. F2A, spouses and under 21 children of green card holders. F2B, unmarried adult sons/daughters of green card holders. F3, married sons/daughters of U.S. citizens. F4, siblings of U.S. citizens. What determines the wait? Two key tools matter when tracking your green card timeline. The monthly visa bulletin, which tells you when your priority date becomes eligible. USCIS processing times, which tell you how long the agency takes once your application is submitted. Immediate relatives can skip the bulletin entirely and apply straight away. Why Indians wait so long? It's not about favoritism. It's just maths, Singh said. The volume of Indian applicants is huge, but the law restricts how many green cards can go to each country. That's what causes the bottleneck. He added, the real cost is human. Families separated for decades, siblings growing old in different countries, and children aging out before their number comes up. What applicants can do if delayed. In some cases, applicants can take legal steps if their application is stuck for too long. Couples sponsoring spouses should prepare thoroughly to avoid delays. If the wait becomes unreasonable, filing a writ of mandamus is an option to compel uscis to act, said Ketan Mukherjee, senior partner at Burgeon Law. What counts as marriage fraud? U.S. immigration officials are strict about marriage-based green card applications. The following are considered marriage fraud: entering into a fake marriage for money or favors, both parties knowingly entering a sham marriage, deceiving someone into marriage for immigration benefits. USS investigates suspicious cases thoroughly, and penalties can include visa denial, fines, and removal from the country. U.S. steps up action against visa fraud and illegal immigration. The U.S. government has launched a new interagency initiative to target visa fraud and prevent illegal immigration. The U.S. Embassy in India said in a post on X on May 15th, the embassy issued a warning that individuals found guilty of visa fraud will face permanent bans from entering the United States. As part of the broader crackdown, the U.S. also plans to impose visa restrictions on foreign governments that are found to be facilitating illegal migration to the country. This initiative comes as the Trump administration intensifies its border security policies. The White House stated that the U.S. is now witnessing the most secure border in modern American history, citing a 95% drop in illegal border crossings and a 99% reduction in the number of gotaways, individuals who cross the border without being apprehended, as per a report by the Times of India. Separately, the Department of Homeland Security announced a voluntary departure program for undocumented migrants. Under this program, individuals who choose to leave the U.S. on their own will receive $1,000 and full coverage of travel costs. Hoes who use the CBP Home mobile app to declare their intention to return home will be deprioritized for detention and formal removal. According to a report by the Times of India, Homeland Security Secretary Kristi Noem said that voluntary return is both the safest and most cost-effective option. DHS has already arranged flights, including a recent one from Chicago to Honduras, and more are scheduled. President Donald Trump stated that self-deportation allows migrants to keep the possibility of legal return in the future. However, immigration experts caution that choosing to leave while in removal proceedings can affect ongoing asylum cases and future legal status in the U.S. The current self-deportation initiative uses a digital platform that was originally designed during the Biden administration for booking legal entry appointments. It has since been repurposed to support voluntary returns. While the administration hopes this move will cut enforcement costs, past efforts have shown limited success in ensuring that returnees remain in their home countries. Trump administration threatens groups that distributed federal aid for migrants. The Trump administration is accusing some state authorities and nonprofits of, in effect, smuggling or harboring migrants after they provided food and shelter for such people, even though the services were funded through federal government programs, and those being helped had already been processed and released by immigration officials. The administration has also withheld funds it owes to service providers, which spent up front to support vulnerable families recently arrived in the U.S., on the good faith agreement that, as is usual practice, they would be paid back by Washington. The nation's shelter and services program, administered by the Federal Emergency Management Agency, was created with the explicit purpose to financially support service providers that were struggling to welcome migrants and asylum seekers who have been released from federal immigration custody. Yet in an ominous recent letter, SSP funding recipients were told that the Trump administration was pausing further payments amid significant concerns that government money had gone toward institutions engaged in or facilitating illegal activities, with allusions to serious crimes such as transporting undocumented immigrants and shielding them from detection. The then interim FEMA administrator, Cameron Hamilton, gave no evidence to support his agency's sweeping allegations. Hamilton has since been fired, but he had told SSP grantees they had until mid-April to produce the names, contact information, and any related documents for the migrants they had served, while warning that they would need to formally attest to not having knowledge of their personnel or contractors committing immigration-related crimes. I was flabbergasted that this would happen, And then I find that the letter, it made you look like a common criminal, that you were aiding and abetting those that were in need of food, said Melanie Samuels, CEO of the Campaign Against Hunger in New York. Samuels' organization had not sought the SSP grant. They were allotted in fiscal year 2024 for nearly $512,000. In fact, when New York City saw a significant increase in the number of arriving migrants as the hard-right Republican Texas governor, Greg Abbott, deliberately bussed them there as a political provocation, and then word of mouth spread about a universal right to free shelter. The Biden administration had recruited the Campaign Against Hunger to distribute food to newcomers. The organization was already serving thousands of families each week from all walks of life, including migrants, and it stepped up its work to attend to the acute extra need. Samuels was just one of many in the U.S. who received FEMA's threatening letter, though other organizations and local governments declined to comment as they attempt to navigate what some feel is an intimidating situation amid outrage that their humanitarian work is being portrayed as criminal activity. The Campaign Against Hunger has spent several $100,000 on food that expected would be reimbursed through the SSP fund. That's part of $1.3 million in rescinded or frozen grants affecting their budget as part of the Trump administration's cuts, which in practice has meant slashing some services. And watch it with concern as people go hungry. We don't have the resources. We don't have the food. My staff just met with me and said, "What are we going to do?" Samuel said, "It's not like something changed in families who are in need all of a sudden are not in need," she added, pointing to recent mass layoffs and other hardships that are making her work more urgent than ever. It's that the lines are constantly growing. Like the Campaign Against Hunger, many of the SSP grantees cater to diverse populations, not just migrants, and provide essentials like shelter and food. So the government's decision to hold back reimbursements for costs that organizations operating on thin margins have already incurred may cause suffering for both non-citizens and Americans who rely on their help. Providing the services that you're specifically contracted by the federal government to do, and to then be accused of a crime for fulfilling the terms of the grant, is frivolous and baseless and targeted harassment, said Kristen Etter, Director of Policy and Legal Services at the Texas Immigration Law Council. The FEMA letter is in effect a copycat of a tactic pioneered by Texas's all-Republican leadership, which for the past few years has deployed myriad state and federal laws to try to incriminate 10 organizations that serve immigrants in the state and intimidate others into abandoning their work. For instance, in a court filing, Texas's Attorney General Ken Paxton and his subordinates insinuated that NGOs could become silent partners in cartel trafficking operations unless his team prevailed in shutting down an organization that has served migrants for decades without problems, supposedly because it was operating a stash house and harboring non-citizens. "We're just seeing the exact same playbook, but at the federal level," Etter said. And it is not just migrant-serving organizations being targeted by the Trump administration in this way. The Federal Bureau of Investigation is similarly accusing environmental groups that receive grants from the Environmental Protection Agency of potential conspiracy to defraud the United States, and has asked Citibank to freeze their bank accounts, the New Republic reports. Meanwhile, FEMA has terminated the SSP grants, saying they're used to support undocumented immigrants, including asylum seekers legally awaiting court dates, is not consistent with DHS's current priorities. According to CNN, the agency is considering deploying leftover funds from the program for immigration enforcement. As for the FEMA letter, some SSP recipients, like the City of San Antonio and Catholic Charities of San Antonio, have decided to comply with its demands, saying they are not providing any information that the government doesn't already have. Others in Texas, such as El Paso County and its local nonprofits, are less affected by the federal government's threats because they never asked for reimbursements through the grant or asked for far less than their allotment after predicting that it would be difficult to access the funding under the Trump administration. In New York, the Campaign Against Hunger has replied by requesting more time. But Samuels doesn't understand what FEMA wants from her, given that the program already requires periodic reports, and she has cooperated. Now she's witnessing her communities suffer an emerging hunger crisis that is even harder for her organization to address. "I don't think those that made the decision to cut these programs understand hunger," she said, adding, "They might never have been hungry before." FEMA responded to Guardian's request for comment by blaming the Biden administration for spending hundreds of millions of federal dollars housing illegal aliens in our country on American taxpayers' dime. The agency then repeated unsubstantiated allegations that a large hotel in the center of Manhattan that was turned into a migrant processing center had served as an operations base of the transnational Venezuelan gang Trenda Aragua, and added, in part, that the Homeland Security Secretary, Kristi Noem, has directed FEMA to implement tighter controls on federal funds. The open borders gravy train is over, and there will not be a single penny spent that goes against the interests and safety of the American people, said the Homeland Security Assistant Secretary, Tricia McLaughlin. What to know about birthright citizenship as Supreme Court weighs blocks on Trump's order to end it. The Supreme Court on Thursday heard oral arguments over President Donald Trump's emergency request to roll back nationwide injunctions blocking his executive order to end birthright citizenship. The rare May sitting of the court sets the stage for a decision by this summer on whether Trump can move forward with plans to limit U.S. citizenship only to children born on American soil to lawful permanent residents. The case is also expected to address the legality of individual district court judges single-handedly blocking a presidential policy nationwide. Trump is seeking to dissolve judicial orders preventing mass federal layoffs, funding freezes, and expedited deportation protocols. For more than a century, courts and the government have interpreted the 14th Amendment's Citizenship Clause to apply to anyone born in the U.S., regardless of the citizenship status of a child's parents. The amendment, ratified after the Civil War, states that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Solicitor General John Sauer kicked off the first Supreme Court oral argument over Trump's second-term policies by arguing that the ability of one district judge to issue a nationwide order creates a fundamentally unfair legal playing field for the government. Our primary contention is that the Citizenship Clause related to the children of former slaves, not to legal aliens who weren't even present as a discrete class at that time, he told the justices. Sauer said that national injunctions force district judges to rush their high-stakes, low-information decisions, encourage forum shopping, and prevent the percolation of novel and difficult legal questions. They operate asymmetrically, forcing the government to win everywhere, while the plaintiffs can win anywhere, said Sauer, who last year argued on behalf of Trump in a personal capacity to push for presidential immunity. His claim was immediately met with skepticism from Justice Sonia Sotomayor, who suggested that such a theory would not only limit the ability of the district court, but also the Supreme Court from issuing nationwide relief. That makes no sense whatsoever, she said before making an analogy to when the balance of power shifts in Washington. When a new president orders that because there's so much gun violence going on in the country, and he comes in and he says, I have the right to take away the guns from everyone, and he sends out the military to seize everyone's guns, we in the courts have to sit back and wait until every named plaintiff gets, or every plaintiff whose gun is taken comes into court, she asked. On the issue of the legality of Trump's executive order to limit U.S. citizenship only to children born on American soil to lawful permanent residents, Sotomayor was clear on where she stood. The order, she said, was unlawful. As far as I see it, this order violates 4 Supreme Court precedents, and you are claiming that both the Supreme Court and no lower court can stop an executive from universally violating those holdings by this court, Sotomayor said. Both Justices Neil Gorsuch and Amy Coney Barrett pressed Sauer in a series of exchanges over whether eliminating nationwide injunctions could create a situation where unlawful executive orders are in place for too long a time before the Supreme Court can weigh in to rule on their legality. General Sauer, are you really going to answer Justice Kagan by saying there are no way to stop the EO nationwide expeditiously? Barrett asked. Sauer answered stating that using the normal process of the courts and applying clear-cut Supreme Court precedent could ultimately settle such issues quickly. The exchange came as Justice Kagan questioned whether the impact of abolishing nationwide injunctions would effectively inject more chaos in the court system by requiring individual plaintiffs, like those subject to having their citizenship revoked by Trump's birthright executive order, to file piecemeal lawsuits in courts across the country. Sotomayor also pushed back against Sauer's arguments that the Supreme Court would benefit from the percolation of lower courts issuing opinions that would help the high court decide weighty issues over actions taken by the administration. We have most courts who've percolated this issue and said, you're violating precedent. Not only precedent, but the plain meaning of the 14th Amendment of the Constitution, she said. Respectfully, I think what we have are lower courts making snap judgments on the merits that ignore the fundamental principle of the 14th Amendment that was about giving citizenship to children of slaves, not to children of illegal immigrants, Sauer answered. But some of the justices suggested that the impact of limiting nationwide injunctions might be bearable. Chief Justice John Roberts noted that the Supreme Court has gotten better at hearing cases much more expeditiously, referencing how a legal challenge related to TikTok made its way through court in a matter of months. We survived until the 1960s without universal injunctions, Justice Clarence Thomas added. Justice Ketanji Brown Jackson raised concerns that preventing federal judges from issuing nationwide orders would essentially create a catch-me-if-you-can system of justice in which individual citizens can only protect their rights if they have the resources to file lawsuits. I don't understand how that is remotely consistent with the rule of law, she said. Sauer argued that current system of nationwide injunction instead forces the Trump administration to race from court to win every case challenging their policies, citing the flurry of lawsuits and injunctions blocking the Pentagon's transgender service member ban. I think that catch-me-if-you-can problem operates in the opposite direction, where we have the government racing from jurisdiction to jurisdiction, having to sort of clear the table in order to implement a new policy, he said. The justice system, he argued, should work more slowly and allow the percolation of novel legal issues rather than rush to judgment. But Jackson pushed back, saying that delays could enable the enforcement of unlawful policies. If the government is saying no lower court can completely enjoin it, it actually means that the government just keeps on doing purportedly unlawful thing, and it delays the ability for this court to reach the underlying issue, she said. Kelsey Corcoran, a senior lecturer at Georgetown University Law Center who is representing the individual plaintiffs, called the President's executive order on birthright citizenship blatantly unlawful and should be blocked because it violates the Constitution, federal law, and Supreme Court precedent. The government is wrong, she said. It is well settled that preliminary injunctions may benefit non-parties when necessary to provide complete relief to the plaintiffs or when warranted by extraordinary circumstances, both of which are true here. Corcoran argued that the nationwide order should be allowed in issues involving fundamental constitutional rights. Barring the legal relief outright, she said, would allow individuals to be irreparably harmed. It's a lose-lose-lose proposal that the government is offering, Corcoran said. Kagan suggested that the middle ground approaches are unlikely to resolve the issue, though she acknowledged that the issue of nationwide injunctions has irritated presidents from both sides of the aisle and the High Court. What's problematic about it is that the courts keep deciding the same way, and nobody really thinks that the lower courts are going to do anything different, she said. On his first day in office, Trump signed an executive order unilaterally declaring that only newborns whose parents have permanent legal status are subject to the jurisdiction of the U.S. and therefore eligible to be citizens. This administration believes that birthright citizenship is unconstitutional, White House Press Secretary Caroline Leavitt explained during a February briefing. 3 different sets of plaintiffs sued to block the order, including a group of 22 states, immigrant advocacy groups, and pregnant women whose soon-to-be-born children would be affected. Birthright citizenship is at the core of our nation's foundational precept that all people born on our soil are created equal regardless of their parentage, attorneys for the immigrant advocates wrote in legal briefs. An estimated 150,000 children are born each year in the U.S. to parents who are not legal permanent residents, according to government data. Instead of the right to full participation and belonging in their home country, the United States, these children will be forced to live in the shadow, the states warned in court filings, under the constant risk of deportation while the appeals run their course. Federal judges in Maryland, Massachusetts, and Washington state, and 3 federal appeals court panels have issued nationwide injunctions keeping the Trump policy on hold during litigation, concluding that it very likely violates the Constitution and high court precedent. I've been on the bench for over 4 decades. I can't remember another case where the case presented is as clear as it is here, said Judge John Kokenauer of the Western District of Washington during a January hearing in the case. This is a blatantly unconstitutional order. In 1898, the Supreme Court directly addressed the question of citizenship for children born to non-citizens on U.S. soil, ruling in the landmark case U.S. v. Wong Kim Ark that they are Americans under the law. The 14th Amendment, in clear words and in manifest intent, includes the children born within the territory of the United States of all other persons, of whatever race or color, domiciled within the United States, wrote Justice Horace Gray for the 6-2 majority. Every citizen or subject of another country, while domiciled here, is within the allegiance and protection and consequently subject to the jurisdiction of the United States. The issue arrives back at the High Court in an unusual posture. Neither side has briefed the justices on the constitutionality of the executive order. Instead, the primary dispute is over the scope of injunctions issued by individual district court judges. It focuses only on whether it is appropriate for courts to issue nationwide injunctions against the president's egregiously unconstitutional executive order, as opposed to remedies limited to people directly involved in the litigation or those living in states that have sued the government, said Ilya Salmon, a constitutional scholar at the Cato Institute. The Trump administration has complained that judges should only be allowed to block a contested policy insofar as it impacts the actual plaintiffs who brought the case, not block it universally. Only this court's intervention can prevent universal injunctions from becoming universally acceptable, Acting Solicitor General Sarah Harris wrote in the government's application to the court. Many of the administration's high-profile attempts to reshape the federal government, sharply curtail federal spending, transform immigration policy, and limit protections for LGBTQ people have been blocked by nationwide injunctions issued by district courts. Justice Department attorneys from administrations of both political parties have long complained about the overuse of nationwide injunctions and alleged incursion on executive branch power. The court may use this case to articulate parameters for when such sweeping injunctions are warranted and when they are not. This court should declare that enough is enough before district courts' burgeoning reliance on universal injunctions becomes further entrenched, Harris said, calling on the justices to narrow the injunctions applied to the Birthright Citizenship order. Immigrant advocates, civil rights organizations, and Democratic state attorneys general have warned that blocking Trump's birthright citizenship in some places, but not others, or exempting a small group of plaintiffs, but not others, would create chaos. A situation where Trump's order is enforced for some people, but not others, or alternatively, in some states, but not others, creates obvious confusion and anomalies, he said, especially when it comes to policy, citizenship rules, that is supposed to be uniform throughout the nation. Some legal scholars say it may be impossible for the court to address the question of nationwide injunctions without also resolving the underlying dispute over Trump's attempt to redefine birthright citizenship. They're going to have to address the whole thing, said Josh Blackman, a constitutional law scholar and professor at South Texas College of Law. The only way to avoid the scope of the injunction question is to rule on the merits. I believe they're going to rule against Trump. He gets maybe 1 or 2 votes, but not much more than that. As immigration policies tighten and enforcement intensifies, both migrants and aid organizations face increasing uncertainty. From green card delays to court battles over constitutional rights, the landscape remains complex and deeply contested. That is all for today in this video. What are your thoughts on this? Please let us know in the comments section below. Thanks for watching the entire video. Hopefully, the information is useful to you. See you later in the next video. Till then, take care.
Obtaining US a green card through family ties varies in speed. Immediate relatives of US citizens, spouses, parents, and children under 21 receive priority at bypass visa bulletin delays. However, siblings and adult children often face wait times of 10 to over 20 years, especially for applicants from countries like India due to a 7% per country cap. The visa bulletin and uscis timelines are crucial for tracking progress. Simultaneously, the US has increased its crackdown on visa fraud and illegal immigration, warning that the fraudster could face lifetime. Hence, the government is also limiting visas for nations supporting illegal migration and has launched a voluntary departure program offering $1,000 and travel costs via the CBP Home app to reduce detention expenses. Trump administration has also targeted non-profit aiding migrants, accusing them of harboring undocumented immigrants. FEMA halted shelter and services programs funding, forcing service cuts. Legal battles are also unfolding over Trump's push to end birthright citizenship, with the Supreme Court examining whether to limit nationwide injunction against potentially unconstitutional policies.